Today's date is August 30th, 2020, of course, and the panel for this morning is Judge Carr, who you can see on the screen, and Judge Callahan, who's with me as well. And we are going to hear two video arguments today. The first case we'll hear is Crandall versus Crandall, case number 21CA0078M. Each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. I'll be keeping track of the time, so if you're going to be reserving time, just let me know. As you know, the oral arguments are recorded. They are posted on our YouTube channel, so we ask that you keep your voice up and not refer to children or victims, although that's not an issue in this case. I guess that's a good public service announcement before we get started. All right, I can assure you, Judge Callahan, Judge Carr, and I have read the brief, so we are here for oral argument. Would you like to reserve some time on behalf of the appellant?
Yes, Your Honor, I'll reserve 2 minutes on behalf of the appellant.
All right, and I may interrupt you to let you know that you're getting close to that time.
Okay, thank you, Your Honor.
All right, you may proceed. Thanks.
Your Honor, may it please the court. And I'm Attorney Adam Morris on the behalf of the appellant, Liz Crandall. And Your Honors, the crux of this case revolves around the fact that a continuance was denied all the way back when the trial happened in 2017. And the issue is that the appellant wife, she had a breakdown in her relationship with her attorney, who was L. Ray Jones at the time. And she could not communicate with him. She didn't believe that things were being completed in time on her behalf. So she obtained new counsel that she thought was competent and could handle the case for her. The new counsel got on the case 7 days prior to the trial date. He requested a continuance, first in writing, and then orally, it was discussed at the beginning of the trial. He laid out all the factors for why why wife should receive a continuance, including the fact that he just was retained on the case. It was a complicated case that involved a business, involved real estate appraisals, involved some tracing of funds of separate property, and it involved a very complex spouse support issue. He laid out the factors for the judge. He went through all the different issues, the fact that he just received the file. He was having issues making sure he could subpoena witnesses. And the judge, on the record, her response was that basically, I gave you time to meet with former counsel before this trial. She gave him 3 hours to meet, and that you can subpoena your witnesses while this trial is pending. That decision just lacked in basic fairness for wife. And this issue has been up in this Court of Appeals once before. And the decision, the previous Crandall decision, indicated that the decree was not a final appealable order and therefore was remanded for that purpose. However, in the dissenting opinion said that the dissenting decision said that the case should be remanded for a new trial due to the lack of continuance, due to all the factors that were laid out in the motion and presented at the hearing. And that's the main issue that's happened in this case, which has caused all these other issues that have come up since that occurred. And I think it caused for there to be a lack of preparation at the trial. And when there's a lack of preparation at the trial judge definitely does not necessarily get the necessary information. And as you can see, my client could be clearly prejudiced by this decision from the judge. And her prejudice is that she had a attorney who was representing her, who was telling the court, was pleading to court, I am not prepared, I am not prepared. And the judge's response was, well, this case has been pending for 9 months and we're going to move it forward. Opposing counsel did not object to the continuance. There were all the parties and other witnesses were basically local, so they wouldn't be prejudiced. And even on the record, the court said, to Attorney McCarter, who was opposing counsel representing the husband, how do you feel about this continuance? And Attorney McCarter said he didn't object. He said, I'll defer to the court. So that is the main issue in this case, is that appellant is requesting that she receive a new trial so that she has time to prepare her case and present the evidence for the court.
Attorney Morris, was there any expert testimony that wife was unable to present to the court due to the failure to continue the case?
Yeah, she had some appraisers for the real estate that she did not get to present to the court, and I've laid that out in my my brief. So yeah, she did have expert testimony, and also there was never a valuation done. I mean, this is one of the issues with her attorney, L. Ray Jones, at the time, is there was never a valuation done on husband's interest in the business. There was a personal injury claim in case that was pending or was at issue, and that was never really researched by L. Ray Jones at the time.
Counsel.
Yes, Your Honor.
I'm just going to suggest to you that we don't always use attorneys' names.
Oh, I'm sorry. I apologize, Your Honor.
That's okay.
I'll say
you my preference.
Yes, it's her former counsel. I will indicate, and that was her issue with her former counsel, is that she felt like there was a breakdown in that relationship. So moving on to the other issues in the case. The second main issue is there's this UBS IRA account, and this court remanded the case back down to the judge to make it a final appealable order because there was not a determination on necessarily the separate and marital nature of that account. If you look at the decision from the judge, she still has not necessarily made a decision on the separate versus marital nature of this individual retirement account. The court has indicated that a passive growth analysis should be completed subsequent to the trial. So essentially what happens is there was commingling of marital and separate money in this individual retirement account. What usually happens is a passive growth analysis is done prior to the trial date. An expert report is prepared. The expert report is provided to the court, and there's cross-examination of the expert if there's not necessarily agreement. Well, what the judge's order in this case is that after the trial is completed, now this passive growth analysis is going to be completed to determine what is the separate versus marital nature of this account. And as I've laid out in the brief, the trial court had the obligation to determine the separate marital nature at the time of the trial, and also the husband had the duty to trace he had the burden to trace his separate property in that account, and he did not do that at that time. So what appellant is requesting is that account be treated as either a marital account, or there needs to be it needs to be remanded back down to have that determination, and as her position is, have the determination at the new trial. And that goes back to the issue of not necessarily having all of the information to make the best decision in this case. I'll move on to spousal support. Spousal support, the court determined that that there was going to be no spousal support in this case. If you look at the findings, there are significant issues in the findings of fact. And those issues surround, first, the court found that they both have significant assets. I think that the evidence that was presented at the hearing and even in the decision, I mean, husband clearly has significantly more assets than wife. He's got an ownership in a business that is providing distributions to him in approximately $45,000 a year. Wife simply just had a TD Ameritrade account and an interest in her home. But husband had a significant IRA, which it goes back to the issues. We don't really even know how that IRA is being divided. So it's hard for the court to determine who has significant assets because the court did not really determine how that IRA is going to be divided. If you go to the income of the parties, I find that the court erred in how they looked at the income of the parties. The court indicated that husband earned approximately $130,000 in the 2 years before the trial date. The court also indicated that wife did not earn any income the 2 years prior to the trial date. Therefore, clearly, husband had an earning ability. Now, husband did get in a motorcycle accident while the case was pending. However, the court failed to indicate that husband was scheduled to return to work October 1st, 2017, and that was shortly after the trial date. So for the court to find that husband did not have an earning ability and have income, the appellant, the wife, would find that that would be a clear error by the trial court. Also, husband did have actual income coming in besides his W-2 wages. As I indicated prior, he had S corporation distributions from his ownership in a business of approximately $45,000 a year that were coming to him. In court, as this court could see, this is not a short-term marriage. These parties were married for a significant period of time, and wife should be entitled to some spouse support, and wife's argument would be that she's kind of been left in a very destitute position compared to husband. And as I just go back to my previous point, is if you look at the spouse support factors, the court has to look at the assets and liabilities of the parties. And as I indicated previously, the court never even determined the actual retirement account how the retirement assets should be assigned in this matter.
Counsel, what, if anything, did the prenuptial agreement say about spousal support?
The prenuptial agreement did not say anything about spousal support. And there was some discussion at the trial court where both parties believed that the prenuptial agreement had discussed spousal support. But the prenuptial agreement did not have any discussion of spousal support.
All right, Counsel, you're at 2 minutes and 18 seconds total time left. I'll just let you know that as you continue or reserve.
Yeah, thank you, Your Honor. I'll pause here and I'll reserve the remainder.
All right, you'll have 2 minutes and 18 seconds then for your rebuttal.
Thank you, Your Honor.
15 minutes, Counsel.
Thank you. May it please the court, Mr. Morris, Your Honors. My name is Chris Sopperly, and I'm the attorney for Mr. Crandall. I'll set my time. And so the first thing I would address is I will go to the main focus of Mr. Morris's and Ms. Crandall's argument, which is that there was not a continuance that was that was granted in this particular case. So the divorce was filed on September 6th of 2016, and the parties had actually come to a pretrial the middle of May of 2017, some almost month before trial, and had indicated to this court, and the court even mentioned it in the opening, that there were no one had indicated any issues of being prepared for trial that was coming up. In what happens at times, at end of the case, end of cases, we all have clients that are not necessarily happy with their counsel. That doesn't necessarily mean counsel wasn't prepared for this case. I appreciate the request from Ms. Crandall, both in her motion as well as what she stated, what her counsel, her subsequent counsel, prior to Mr. Morris, had stated on the day of trial. All that was self-serving statements to try to get this case to be moved, but there was no evidence that the first counsel wasn't prepared for trial. In fact, if you look at what subsequent counsel had stated on the record, was he was given a couple of boxes for trial that were prepared a week prior. Indicates that on the record, and he also indicates that there were witnesses that were subpoenaed, and throughout the trial, the counsel had indicated, yeah, I had a witness here. At one point, I think I referenced it in our brief. I don't remember which page, but it's in the brief. It said that that it sounded like an appraiser had shown up to testify on Tuesday, and he was unable to get a hold of this appraiser after that date. That was in the transcript. I think it's page 112, 113 on trial transcript June 15th of 2017. And it indicates that the witnesses, there were witnesses that were subpoenaed, specifically an appraiser. It's unfortunate subsequent counsel didn't have that relationship with our appraiser to try to make sure that they're going to be there for the trial and at the appropriate times, and kind of run into that problem if you attempt to retain additional counsel that late in the game. And there was indication that Ms. Crandall this was not her doing in terms of requesting or requesting continuance. Well, hiring new counsel 10 days prior to trial because you're unhappy with the way your present counsel was getting ready to handle the case, that actually is an action. She could have done something much sooner. This case, as the judge had mentioned, the case has been pending for 9 months. There's a lot of time to kind of get with your counsel to determine whether they're doing what they need to be doing. Ms. Crandall would have known that this was a complicated case if she was concerned about the division of assets or the valuation of a business, which, by the way, again, that's brought up at the end, but that could have been a decision that initial counsel had made with Ms. Crandall along the way. There's no need to evaluate the business because it's a premarital, it's a non-marital asset. We don't know because we don't have.
Counsel.
Yes.
Let me interrupt you because I guess, the points that you're making, those are all points that could have been raised prior to trial. But it's my understanding that there was no objection to the continuance.
That's correct. Mr. McCarter did not, and by the way, that's present counsel is my partner. So in terms of utilizing his name, he did not object to a continuance on the day of trial with the court. To be frank, the court, this court, I think it was just leave it up to what the court is going to decide. And the fact that the court had already denied the continuance was the expectation that was going to happen again that day.
Okay, because then I just want to remind me then, if you don't care, when the written motion was filed for continuance, then you did file a written motion opposing that?
I don't, Your Honor, I don't have that in front of me, whether a written objection was
Yeah, it's
was,
my understanding you didn't, but I didn't want to, recollect incorrectly. So that's why I was asking.
and if I don't have the docket right here in front of me, if it doesn't say it there, then we would not, if it doesn't say it in there, we did not oppose a continuance through.
And it's
Again.
awkward when the cases come back. Are you okay? You're frozen, Mr. Apperly. Can you hear us?
Because of the fact that it went against the local rule that says the any continuances should be set forth 1 week prior to trial.
Counsel, I was starting to ask you another question and you were frozen, so I apologize.
I apologize.
Yeah. We go through this. It's unfortunate. But at any rate, my question is, it's kind of like the elephant in the room. It gets awkward whenever something is remanded and there's a dissent. And so, in my dissent, the majority of the court didn't reach the issue of whether continuance was appropriate because they felt it wasn't an FAO. I thought it was an error issue and a continuance should have been granted. This is your opportunity to tell me exactly why I'm wrong.
I apologize. I missed that entire question because
Oh.
everything froze up on me, Your Honor.
It was such a good one too. No, I basically just want to say, why was I wrong in my dissent? This is your opportunity to give me the information, argue why I was wrong in my dissent, previous dissent that says that that the continuance wasn't, not granting the continuance was an abuse of discretion.
Well, and again, Your Honor, with all due respect, in indicating that you were wrong in that, it's, again, there are times to be able to request a continuance. I don't think, I appreciate what Mr. Callow put on the record. Those were all self-serving statements as an attorney coming in saying, hey, I'm not prepared. But there really wasn't any indication, no affidavits that's prepared by Ms. Crandall on this to say, hey, I have not had any communication with Mr. Jones. Mr. Jones showed up for trial and had also previously had turned over all the evidence that was still used at trial and had subpoenaed witnesses throughout the to be prepared for trial, that, and some of those witnesses Mr. Subsequent counsel did not use. And so I understand that Ms. Crandall felt that maybe her counsel wasn't prepared, but that was something that I think that she could have made a determination prior to even leading up to the pretrial. The court held a pretrial 30 days prior, and usually by the pretrial, you're going to know whether you're ready to go or not for trial. And for whatever reason, in between those 30 days, Ms. Crandall made a decision and really, I know Mr. Moore said 7 days, I think it was 5 days in which Mr. Callow entered appearance in this particular case. So to come to court, we need valuations, we need evaluation of the business. Those decisions may have already been made by competent counsel prior, at the last minute, Ms. Crandall having some buyer's remorse and then not really giving anything other than her attorney making those statements in open court. Hey, this is what we need to move forward. If you take a look at the trial, everything was able to be put out. And in fact, there was a witness that did show up that subsequent counsel wasn't able to bring back for an evaluation of a property. And so,
excuse me a minute. Was any hearing that took place on this actually on the day of trial, on the continuance?
it
I
appears
assume there was a hearing.
Well, it appears that there was in terms of the continuance request, it appears that was, or the request was dealt with at the very beginning of the trial, and subsequent counsel had an opportunity to not only talk about a denial of continuance, but a oral request again for a continuance. And so, but But was a hearing, did
Hang
they
on.
have any of the parties testify? No, no parties testified with regards to.
Did the trial court inquire? I mean, I know the trial court let new counsel have a 3-hour discussion with former counsel. Did the trial court make any inquiry of former counsel as to what he did or didn't do?
Well, in terms of actual testimony, maybe even asking some questions from either well, specifically from Ms. Crandall, there was no testimony. There's nothing with regards to that, but there was some discussion on there. But it does not appear that initial counsel was brought in for a hearing to find out what he had or hadn't done.
But initial counsel was there and the court could have inquired. Is that correct?
Yes, and in fact, the subsequent counsel had indicated that he had been there for 3 hours to having some conversation about the case, and then they moved forward, and the court let original counsel go.
Thank you.
I appreciate, in terms of the separate, real quick, I know that you guys have a lot of questions about the continuance. I'm happy to do any, so can go over those, but I just want to touch base briefly on the UBS account. What Mr. Morris is talking about is done in a lot of cases. If there is some separate property that's part, so first of all, the court determined there was 2 pieces of separate property. That's in there. There's about 98,000 and 67,000, made that specific finding, and then said, hey, Cuter's going to need to figure out any additional retirement division based on the terms of the marriage and anything that's been placed into that account. That's normally done by these courts, routinely done, quite frankly, through Cuter consultants or through a provider that handles that. With regards to the spousal support, and I apologize, I don't, Your Honor, Judge Teodoso, how much time do I have? I didn't see.
You have 2 minutes and 38 seconds left.
Thank you. With regards to the spousal support, the court went through an extensive analysis and went actually through every single factor in terms of discussing the different factors based on the testimony that was presented to it at the time of trial. And really what's being discussed today is just that Ms. Crandall didn't really like the outcome of it. I mean, of the analysis, but it wasn't that the court didn't actually go through an analysis. The court went through a specific analysis and actually touched upon each of the different factors as to what, why it made the decision with regards to spousal support. As far as Mr. Crandall and his ability to work, his testimony was, listen, I've been told I could go back to work in October, but I'm not really sure I'm going to be able to do that. That's not a resounding, hey, I'm cleared to go to work. It's whether he's able to or not. As far as it touched on the Beach Road property and really the real estate properties, the court actually went through a simple analysis in its decision with regard to what is separate property and what isn't, in terms of at the time of the marriage, at the time of the divorce, and how much it's worth versus what's remaining, and went through a simple analysis of what is separate property. I think the court laid it out pretty straightforward. I don't think that's a problem. Fine, in terms of there's an argument in regards to the errors, that the court there's so many errors in this court that it needs to be reversed. I mean, that's almost as I see that quite frequently these days in just about every appeal that comes up. Hey, let's, there were a lot of errors here. We need to recall this back to the court. The court actually went through a proper analysis and found the terms that that weren't discussed. A lot of the terms that Mr. Morris put in there, like a forerunner and four-wheeler. There's a couple things. None of that was discussed at trial. It may have been in a trial brief, but none of it was actually discussed at trial or brought up at trial. I believe that's probably my time, Your Honors. We were
You have about 8 seconds left. Can you answer Just a quick yes, no question. Do you agree that spousal support was not addressed in the prenuptial agreement?
Yes, I do agree with that.
Okay. With that, you are out of time.
Thank you, Your Honors.
All right. And Attorney Morris, before you go, I just noticed I'm on low battery, so I'm going to just plug in here, okay? All right. That way I'll make sure I don't lose you. I'm plugged in and you have 2 minutes and 18 seconds, sir.
Thank you, Your Honor. Your Honor, this continuance issue is just a basic fairness issue. And as in divorces, the parties are going through a very emotional time. A little bit of a different case than just your run-of-the-mill, corporate litigation cases. This court knows. I mean, the parties are going through a very, very hard time. They're trying to get their lives together. They're trying to get the case together. They're doing their best. This is not a case where she was asking for her third continuance. This was the first scheduled trial date, and as routinely happens in domestic relations cases, there's sometimes a breakdown in relationship in the attorney with the attorney. Sometimes there's things that still need to be completed, and a first request to continue into the trial date is not unreasonable. She was not trying to delay these proceedings unnecessarily. She just wanted to make sure that her case could be heard and that she could be prepared. And clearly during the trial, there was, and based upon the decision, there was just some lack of information that was provided to the court, and she felt like she was lacking in preparation. Your Honor, when it comes to the spouse, Your Honors, when it comes to the spouse support issue, this was a 13-year marriage, and husband not only had his working income, but he also had the income that he derived from the business. So the fact that he wasn't working didn't mean that he didn't have income coming in. His tax return showed he had $45,000 a year of additional income coming in, and he was scheduled to go back to work in October. So the court could easily retain jurisdiction over the issue, set a spouse support number, and then when he went back to work in October, it could be adjusted, which is typically done by the trial courts. So the decision on the spouse support was, my client believes, is clearly unreasonable and not appropriate. Thank you, Your Honors.
All right. And that takes us to the end of the argument. On behalf of Judge Carr and Judge Callahan, we want to thank you for appearing today by Zoom and for a very good job arguing the case. We'll take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail a copy of our decision to each of you on the day it's released. And as you both probably know, the decisions are also posted on the Supreme Court of Ohio's website. So once again, we want to thank you for your appearance here today.